Hello everyone, and topic is criminal law, and in this video we will revise the entire topic, namely criminal law. Okay, so as of now we have studied and completed unit 2 chapter, namely criminal law. However, in this special chapter we will revise and will try to condense maximum terminologies of criminal law in an organized form that already we have discussed. But I repeat, I won't be discussing any terminology, rather I will only give the systematic presentation that will help you to keep entire topic on your fingertips. Right? However, if you want to understand any topic or terminology related to criminal law, you can revisit the previous videos. As you know that I covered those topics very comprehensively, isn't it? So let's begin with the topic with its structure. Our topic primarily categorized into two parts. The first one is general meaning of criminal law, and second one is criminal law in India. Under the first category, we have studied the meaning and concept of crime and criminal law. And then we have stages of crimes, and then we have discussed the elements of crime, and then we have discussed the difference between intention and motive. We have discussed all these at first level. However, at the second level, we have discussed some other terminologies, such as under the category of stages of crimes. We have discussed, do you remember? What? Right, it is intention, preparation, attempt, and commission. So there are 4 stages of crime, right? The first one is intention, that of course you need something in your mind before doing any work. Why not it is crime? So whatever, even if it is crime, even then you need to have some intention. Once intention came in your mind, then what will you do? You will start preparing for that. And once you prepared for that, you will attempt. Once you succeed, crime is committed. And you failed, though crime is not committed, but still you will be held liable and will be arrested. So the difference between all these 4 terminologies is, for intention, there is no punishment. Because what is going inside your mind, no one knows. So you cannot be punished. You cannot be arrested for that. But once you start preparation, here there is some confusion. Because sometimes it is not possible even to arrest you, to punish you while you are at preparing stage. But sometimes it is possible, because if there is a strong belief with evidence that you are going to commit some crime and your background supports that. Normally it is not possible, but it is possible. So it is 50-50 kind of. Third one, attempt. And when you attempted, then it is confirmed that you are going to arrested and be punished. Because that attempt in itself the proof of your intention. Right? That attempt, whether it was successful or failure, that doesn't matter. You will be arrested and punished. Of course, in this case, in failure case, your degree of punishment will be lesser, the quantum of punishment will be lesser, but you will be punished, definitely. And once you committed, that is at the final stage, 4th one, then of course, you know that what will be the possibility of that. Okay, now under the second category, that is elements of crime, we have discussed mens rea, remember, guilty mind, And in the stages of crime we have discussed the first one, that is intention. Okay, so mens rea, that is guilty mind, and actus rea, and that is in the stages. Actus rea can be started with the preparation, attempt, and commission, all these three. Okay, because you start doing that, though at the final stage it will be considered, but preparation, the moment you start doing something that involves some action. Okay, so that is actus rea. So elements of crime means mens rea and actus rea. Likewise, it is the general structure of the criminal law that gives the basic understanding of the topic. Once you understand this, then you can easily appreciate the second category, which discusses about the criminal law in India. So now let's check out in the second category, that is criminal law in India, what are the second levels. The first one we have studied, that is objectives, and then we have studied the meaning, and third one we had sources, and the fourth one, that is crimes under the special and local laws. Now, like category 1, here we have also the second level of category. Okay, so let's check it out. Do you remember something that what we have discussed under the heading of objectives of crime? First, understand what is meaning of objective of crime. The objective means the purpose of evolution of criminal law, the purpose of studying the criminal law, and the purpose of setting up the whole system of judiciary. So, can you guess what it could be? Right, that is punishment. And the purpose of punishment is simply to restrain not only the perpetrator or criminal to commit a crime, but also warn others not to commit crime, as its consequences are painful. है कि नहीं? However, over period in time, the purposes of punishing the perpetrator kept changing. Confused? Wait. The following terminologies will clarify your doubts. Okay? In the beginning, the purpose of punishment was to revenge, which means if a person committed crime, which directly means he harmed a person or a person's property, so he must be given the same pain. And this concept is defined through the retributive theory. Right? After a few centuries, time changed and the concept of giving punishment also changed. In this era, the perpetrators were given certain types of painful punishment. Imprisonment was one of them. Not only this, such person used to be deterred so that he cannot repeat such an offensive act. And lastly, such punishment would deter only the perpetrator but also other individuals as well, as no one wants to get pain in reward. Right? So, if you want to avoid such pain, that is punishment, imprisonment, fine, or anything of such type, then don't commit any crime. So simple. So, this era was known as the period of deterrent theory. The third period was the period of incapacitation, which means putting the perpetrators far from the society. It was normally done with the criminals who were really a threat for the society at large. They were even banished, and the purpose behind that was protecting society from this perpetrator. The fourth period was rehabilitation. This is something different from the previous one. By the time people are started emphasizing on the human rights. Though a perpetrator is a criminal, but he has some rights. And secondly, people start thinking to avoid crimes or hate crimes, not the criminals. So in this period, the purpose of punishment became rehabilitation, and its purpose is to make feel the perpetrator that his act was wrong and hence he needs to correct that. And of course, based on this theory, you can call jail as rehabilitation center. Besides, there is one more concept, which is of course not modern, but its presentation and implementation is modern. It is restoration theory, which means if any injury inflicted upon the victim by the offender, then it must be repaired through a state authority. For example, if someone has taken your property, then you can get it back through the judiciary. However, the difference between the first four retributive, deterrent, incapacitation and rehabilitation and the last one, that is restoration, is the first four largely the theories of punishment of criminal law, and the last one, that is restoration, is commonly applicable in civil law, that is civil wrong, such as in case of breach of contract, in case of tort, in case of property dispute, etc. Next one is the sources. Under the sources, primarily we have Indian Penal Code 1860, in short IPC. It defines, categorizes and describes the crimes and respective punishments. Second one is Criminal Procedure Code 1973, or in short CRPC. It defines the procedures and proceedings of criminal investigation and criminal trial. Under this Criminal Procedure Code, we have discussed about the different types of crime like billable, non-billable, cognizable, non-cognizable, compoundable, non-compoundable. So these are the types of crime based on the degree of crime. Okay, and we have also discussed the types of criminal trial, such as warrant trial, summon trial and summary trial. Okay, now third one we have the Indian Evidence Act 1872. It defines the evidence, the kind of evidence, and lastly what are the evidence that can be admissible in the court of law. Lastly, we have a special criminal law based on the category of crime. Time to time, Parliament keeps legislating crime a specific law, which is treated differently than the regular crime. For example, Prevention of Corruption Act, Food Adulteration Act, Dowry Prevention Act, Commission of Sati Act, the Prohibition of Child Marriage Act 2006, the Protection of Children from Sexual Offences Act 2012, etc. Moreover, we have also studied the categories of crime, which define the entity against which crime can be committed. This entity could be a person or property. For example, crime against persons, crime against property, crime against morality, etc. So, this is all for this video. However, I repeat, this video will be beneficial for you only when you have thoroughly understood the previous videos. So, do revise this revision video. But to get maximum benefit of this video, also revise the previous videos. Good luck. See you in next video.